This hearing is entitled Oversight of the SEC's Division of Enforcement. I recognize myself for 4 minutes. There is nothing more important for this subcommittee to do than oversee the SEC. I look forward to the full committee bringing the chair of the SEC before the full committee. I would hope that that would happen either at the subcommittee level or at the full committee level several times each year. But oversight of the SEC is also enhanced by bringing before us the division director of the largest division of the SEC. The Securities and Exchange Commission oversees $100 trillion in securities investments and reviews disclosures of 7,400 public companies, including more than 4,000 exchange-listed public companies. The SEC has an annual budget of $2 billion, supporting 4,500 employees across both the headquarters and the 11 regional offices, the most important of which is now in my new district in Los Angeles. The agency's largest division is the Enforcement Division, with some 1,366 employees, representing a quarter of the SEC staff. The division is responsible for enforcing our securities laws. In 2021, the SEC filed some 434 new enforcement actions, representing a 7% increase. As the chair of the SEC, Gary Gensler, pointed out, the purpose here is to discourage misconduct before it happens. Today, the division faces new challenges in the form of cryptocurrencies and other digital assets. The combined value of these digital assets hit $3 trillion at a peak, from which it has declined. In response in 2017, the SEC established a crypto assets and cyber unit within the Division of Enforcement. That division has brought some 80 enforcement actions related to fraudulent and unregistered crypto asset offerings and platforms, resulting in monetary relief totaling $2 billion. This is by far the most of any federal or state regulatory body. Obviously, there have been recent downturns in the value or purported value of crypto assets. In particular, their enforcement actions depend upon the definition of the word security under a relatively ancient Howey test. The division has determined that XRP is a security and is going after XRP, but for reasons that I'll bring up in questions, has not gone after the exchanges where tens of thousands of illegal securities transactions were occurring. The division faces a number of longstanding challenges. Today, we're considering a number of important bills that are listed for all of the members of this subcommittee and are being considered in this hearing. There is no federal statute defining insider trading. I know Mr. Himes has a bill designed to do just that. And of course, the Newman decision narrowed the definition somewhat of insider trading. Another issue for us to confront is the maximum civil monetary penalties, which some bad actors simply regard as doing a cost of doing business. Recent decision in the Fifth Circuit has called into question the whole use of using administrative law judges, which is the primary method of enforcing our securities laws. The court found a number of problems. Some are constitutional and would require a change in practice if that court decision, which is now in appeal to an en banc review, is upheld. But other concerns of the court are about the inadequate standards that the Congress has put into the statute, and we need to correct those by legislation, probably even if the court decision is successfully appealed. Finally, we're looking at the SEC's use of waivers where bad actors admit to wrongdoing but then don't face the full penalties. With that, I recognize the ranking member for his 5-minute opening statement.
Thank you, Mr. Chair, and welcome, Director. Glad to see you here. And interestingly enough, it's been 4 years since the Director of Enforcement was sitting as you are today. 4 years since this subcommittee had provided oversight for your division. 4 years since members of this committee on both sides of the aisle were given the opportunity to raise concerns over enforcement actions taken by the SEC, and I think it's safe to say this hearing is long overdue, and it is a key element. I mean, it's titled Oversight of the SEC's Division of Enforcement. It is a key element of what this subcommittee's jurisdiction is, and it's been missing. And I appreciate the efforts of the chair, who has been advocating, at least privately with us, about having yourself and having other directors, and frankly, even having the chair. But this is not going to stop as a request from myself, and I think from other members of this committee. This is our constitutional requirement and duty, is to act as the oversight for the administration at all levels. So, you know, the SEC has happened and gone a long way in the last 4 years. In the 14 months since you were sworn in, since he was sworn into office, Chair Gensler has charted a path for the SEC unlike any other time in its 88-year history, from an agency that has a mission to protect investors, maintain fair, orderly, and efficient markets, and to facilitate capital formation. Those three things, let me repeat that. Protect investors, we all agree on that. Maintain fair, orderly, and efficient markets, we all agree on that. But to facilitate capital formation, that seems to have been something that has fallen off of his radar in many ways. And he's embarked on one of the most ambitious rulemaking agendas in our modern era since we've had the SEC. To put this in perspective, the SEC's past 3 chairmen issued half as many proposals in their first 14 months compared to the current chairman. The flurry of activity is evidence that the rapidly evolving enforcement and regulatory landscape at the SEC is an indicator of things to come. I don't think it's going to slow up. In the past, increased enforcement activity at the Commission has signaled that they will act aggressively, pressing the boundaries of their enforcement authority. So of note, it looked no further than the SEC's announcement this past May to nearly double its crypto enforcement unit. While the Commission does not intend to provide any clarity surrounding the application of securities laws to digital assets, the unit plans to focus on violations related to crypto asset offerings. So crypto asset exchanges, crypto asset lending and staking products, decentralized finance platforms, non-fungible tokens, stable coins, et cetera, et cetera. So it's worth mentioning that of the 63 items included in the agency's rulemaking agenda this past spring, exactly 0 pertain to digital assets. In addition to the division's proactive enforcement efforts, your words, not mine, the SEC continues to use its own administrative law judges to adjudicate enforcement actions, a controversial decision that has been used increasingly over the past decade. In a recent court decision, the Fifth Circuit Court of Appeals noted that Congress has unconstitutionally delegated legislative power to the SEC when it allowed the Commission to decide when to use these ALJs. And coupled with the SEC's own admission earlier this year that there was a control deficiency related to the separation of the SEC's enforcement and adjudicatory functions with serious ramifications regarding the fairness of prior SEC enforcement actions for the party subject to those actions. So finally, I would be remiss if I didn't mention the one person who is not here this morning, the chair of the Securities and Exchange Commission, Chair Gensler, but I know he is paying attention, so Chair Gensler, while I appreciate you allowing the Director Grewal to come in before the subcommittee, I can't help but mention your absence and request your attendance. So, Mr. Chair, I'd like to submit two letters from Ranking Member McHenry and myself, one dated October 6th, 2021, and the other May 5th of 2022, requesting Chair Waters to hold a hearing with all 5 of the SEC commissioners. It's now been nearly 3 full years since we last heard from the Commission, and since then, Chair Gensler has proposed 23 rules that await adoption. I think it's long overdue. So, Director, let me caution you with this last word. We should not evaluate the true effectiveness of the regulatory agency or its enforcement program solely based on how many headlines it can generate. That is true of any federal or state regulatory agency in the country, and it's certainly true for the SEC, and I look forward to hearing from you on the impact on our capital markets. With that, I yield back.
Thank you. Today, we welcome the testimony of our distinguished witness, Mr. Gerber Grewal, who is Director of the Division of Enforcement at the Securities and Exchange Commission. Previous to that, he was Attorney General of the state of New Jersey. Director Grewal, you're reminded that your oral testimony is limited to 5 minutes. You'll see the timer, you know the drill, and without objection, your full written statement will be made part of the record, and without objection, the letters referred to by the ranking member will be made part of the record. Director Grewal, you are now recognized.
Chairman, Ranking Member Huizenga, Chairwoman Waters, and members of the subcommittee, good morning, and thank you for inviting me to testify today on behalf of the SEC's Division of Enforcement. Throughout its 85-year history, the SEC has stayed true to its three-part mission of protecting investors, of maintaining fair, orderly, and efficient markets, and facilitating capital formation. Central to that mission is the work of the Enforcement Division. Since my appointment, I've been amazed by the talent and the expertise of the division staff, and I'm privileged to call them all my colleagues. Each year, the Commission brings hundreds of enforcement actions and obtains meaningful relief on behalf of the investing public. And fiscal year 2021 was no exception. Despite the challenges of the global pandemic, we filed 434 new enforcement actions covering a broad range of violations and representing a 7% increase over the prior fiscal year. Yet, many Americans' trust in our financial markets and institutions is at near historic lows. While there's no single cause for that decline, part of it is certainly due to repeated lapses by large institutions and gatekeepers, and the perception by many that they are not being held accountable. It's critical that we at the Enforcement Division do our part to restore that trust and to increase accountability. And I believe that's best done by focusing on three things: robust enforcement, robust remedies, and robust compliance. Robust enforcement means investigating and litigating every type of case within our remit with a sense of urgency. It also means keeping pace with new areas of importance for investors, as well as continually evolving risks. That's one reason we recently added 20 positions to our crypto assets and cyber unit. The expanded unit will leverage the agency's expertise to ensure investors are protected in the crypto markets and against cyber-related threats. Robust enforcement also means focusing on gatekeepers, such as compliance officers, accountants, and attorneys. We can't be everywhere, and gatekeepers are often the first lines of defense against misconduct. So when they fail to live up to their obligations, their professional responsibilities, and when they give cover to corporations or executives engaged in misconduct, investors and market integrity suffer and trust deteriorates. A second component of restoring trust is seeking robust remedies in our cases. Put simply, the remedies we seek must both punish wrongdoers and deter those violations from happening in the first place. To ensure that's the case, we're constantly assessing whether penalties in prior comparable cases have sufficiently deterred the misconduct at issue. Where they haven't, especially with recidivists, we'll seek stiffer penalties. Robust remedies must also include obtaining all appropriate prophylactic relief available. Relief such as bars, suspensions, conduct-based injunctions, and undertakings. Relief which directly protects investors and market integrity by preventing violators from engaging in future misconduct. And while most of our cases will continue to include no admit, no deny settlements, we'll seek admissions from wrongdoers in certain cases, especially in cases where heightened accountability and acceptance of responsibility are in the public interest. Finally, robust compliance is also critical to restoring trust. We're in a time of rapid and profound technological change. Public companies and other market participants need to think rigorously about how their specific business models and products interact with both emerging risks and their obligations under the federal securities laws. And they must tailor their internal controls and compliance practices and policies accordingly. In short, they must work to foster a culture of proactive compliance and responsibility. To ensure that's the case, we're pushing enforcement actions that go to the heart of robust compliance efforts, including actions targeting wholesale record-keeping failures by firms that have either promoted or failed to rein in off-channel communications. All of what I've described requires resources, and the number of enforcement employees has decreased over time. We face significant and mounting challenges as described in more detail in our budget request and in my submitted testimony. At the same time, many of our investigations are becoming more and more difficult as fraudsters find new ways to communicate. Our FY23 budget seeks additional staff to enable us to meet these mounting challenges and to maintain an effective investigative capacity and deterrent presence for the benefit of our markets and investors. I'm confident that with adequate resources and by emphasizing robust enforcement, remedies, and compliance in our work, we'll be able to meet future challenges, achieve our tripartite mission, and do our part in restoring public trust in our financial markets and institutions. Thank you for inviting me today, and I look forward to answering your questions.
Thank you. I now recognize myself for 5 minutes. I'll point out that Chairman Gensler came before our full committee twice last year. He'll be coming before us, I believe, later this year. More is better, but we are certainly doing our job. The ranking member points out that the SEC has a number of regulatory projects. I commend them for having those projects because, as the ranking member points out, we need clarity. If anything, we need another project, and that is to define a security, particularly with regard to the digital world. You've gone after XRP because XRP is a security. But you haven't gone after all the major crypto exchanges that process tens of thousands, if not far more, transactions. If XRP is a security, and you think it is, and I think it is, why are these crypto exchanges not in violation of law? And is it enough that the crypto exchanges have said, well, having committed tens of thousands of violations in the past, we promise not to do any more in the future? Is that enough to get you off the hook for enforcement?
So, again, I can't talk about what matters we're looking at or not looking at. We have brought exchange cases. We brought one last year against Poloniex. I share your concerns that if the securities are...
It's easier to go after the small fish than the big fish. But the big fish operating the major exchanges did many, many tens of thousands of transactions with XRP. You know it's a security. That means they were illegally operating a securities exchange. They know it's illegal because they stopped doing it, even though it was profitable. So if they know it's illegal, and you know it's illegal, and I know it's illegal, I hope you'd focus on that. And then finally, we have Tether, which is a money market mutual fund in every way. It broke the buck. I realize you're reluctant to talk about individual matters, but can you tell us why you went after Terra but not Tether?
Again, it would be inappropriate for me to comment on who we're going after or not going after, but I understand your concerns, and we've added resources to our crypto assets unit to look at issues that put investors at risk, including the issues you've raised in your questions.
Add fortitude and courage as well. You're going to have to take on some cases that you're not certain of winning.
I'm sorry, since the chair. So, Director Grewal, concerned about a couple of things, and I'm going to try to hit this quickly. Unprecedented attempts by the SEC to slip drastic market-changing interpretations of securities laws into otherwise routine enforcement cases. And two, the lack of internal consistency when it comes to the SEC's own ideas about basic foundational elements of market regulation. In a recent case, the SEC, rather than relying on decades of existing case law and legal precedent, presented a case in which it defined a, quote, dealer as, quote, any business that purchases and sells securities for its own account, close quote. So if I'm interpreting this correctly, it quite literally means that every market participant in the country, which means under the SEC definition, regardless of their business model or current regulatory regime, they would somehow now be subject to a widely different and inappropriate, in my opinion, regulatory framework. That quickly, overnight. So, and that's not all. At the same time, in the same SEC, there's a controversial proposal underway in which the SEC is attempting to dramatically expand the definition of this core term, dealer, but this time, a wholly different manner than how your enforcement team defined the term. So two different definitions being presented by the same SEC are in fact wholly inconsistent with each other. So it seems to me that the SEC is frankly brazen about it and thinks that it can rewrite the most basic the elements of securities law whenever it wants to fit whatever purposes it needs at the current moment, with no regard to the effect on markets, the economy, or even internal consistency. And, I'm a guy from Michigan, so I think in car terms, all right? This is a little like we're asking people to build a car, but we won't tell them what the speed limit's going to be. We won't want to tell them what the car should or shouldn't do, what the safety products ought to be on it, but we're going to determine that later. And we're just going to mail you a ticket for speeding. Well, we've got a responsibility to set speed limits and or then to make sure that there's a consistent approach and application of that. So could please illuminate me, what is this approach?
So thank you for that question, Ranking Member. With respect to the enforcement action that you referenced, that's a litigated matter, and we're confident that our position will survive scrutiny in that litigation. We've succeeded in other courts.
How about the inconsistency of it?
I can't speak to the rulemaking that's being done by the rulemaking divisions, and I think it's in a different context, so I'd refer you to my colleagues in those divisions who are responsible for that rulemaking.
Well, if we could get them here, I'd love to ask them. All right, so I want to return to something I brought up during my opening remarks about the ALJs, the administrative law judges. As you know, the SEC announced in April that they had identified a control deficiency related to the separation of its enforcement and adjudicatory functions within its system for administrative adjudications. To quote an article from the Wall Street Journal, quote, "It's the equivalent of a party in litigation having access to a judge's briefs from her law clerks," close quote. So given the scrutiny that the SEC has received over the use of their ALJs, I find this breach very concerning. Quickly, Director, can you assure members of this committee that the cases brought before an ALJ during that time of the breach were fair and fairly adjudicated?
So again, with respect to the breach, as soon as that breach was discovered, it was reported, it was publicly reported, and the matter's under investigation right now internally. But importantly, no enforcement division personnel were found to have access to those materials. It was simply that there was some permissions that allowed people to do so, but they were not accessed.
What gives you confidence? So has there been an investigation to determine that?
It's underway right now, Ranking
So
Member.
then how can you say that there was no breach? You actually don't know if the investigation's still going on.
Excuse me, I'm sorry to talk over you. In the announcement that the commission made, again, it's not being handled by my division. It's being independently investigated, but in the preliminary announcement, it was indicated that the materials weren't accessed. The investigation is going to cover how this lapse happened in the first place.
Has the SEC Officer of Inspector General reviewed this incident?
I would direct you to the Office of Inspector General. I'm not aware of what they're looking at or not looking at.
Well, I will be following up with some additional questions written as well, but underscores the importance of this, so I appreciate it. Thank you.
Thank you. I now recognize the gentlewoman from Missouri, Mrs. Wagner, who for 5 minutes.
I thank you, Mr. Chairman and Ranking Member Huizenga. Director Grewal. Director Grewal? The SEC is expected to finalize its proposal on mandatory climate disclosures in the coming months. Issuers will be required to disclose very detailed and scientific climate-related data, possibly including data on downstream Scope 3 emissions, such as production and transportation of goods, employee commuting, and a host of other indirect emissions. Operationally, sir, how do you plan on handling enforcement cases involving an issuer's disclosure of its Scope 3 emissions?
Thank you for the question. Again, the rulemaking process is being run out of different
I'm talking about the
divisions.
enforcement.
Yeah, I'll speak from an enforcement perspective. We'll take the same approach we've taken to date. We know that ESG and climate issues are important to investors. We know that issuers are making statements about their climate risk already, and we know that investment advisors are marketing ESG funds. So we brought greenwashing cases when they breached their fiduciary duty on the advisor side, and we brought cases against issuers, most recently a litigated case against Brazilian issuer Vale for lying about its ESG policies. And so it's the same thing. If we find that sort of deceit in their statements, we'll bring cases.
But how will the SEC verify whether the issuer has misstated is Scope 3 emissions?
So again, I can't speak to the climate
From an
rulemaking,
enforcement standpoint.
but I'll give you how we're doing it in our enforcement actions. We're relying on experts in our litigated matters.
Experts. Really? Is the SEC an expert in climate policy?
We've retained experts in our case to
You
help
have.
us litigate that matter, yes.
What statute provides the SEC with the direct authority to regulate climate change?
In the litigated matter, there are anti-fraud violations of the federal, violations of the anti-fraud provisions of the federal securities laws. That's a theory in the litigated case.
And you say the SEC has experts on staff to address climate change?
Again, I can't speak to the rest of the SEC. I could
But you just
talk to-
did. I'm just asking, do they have?
I'm just talking about my enforcement division and the people we've retained in that particular case are
You
experts.
have experts.
We've retained them in the litigation, yes.
How will the SEC recruit and hire qualified staff who are both experts on climate change in your purview and securities law disclosures?
So our attorneys and investigators are the experts on the securities laws, and we consult with experts in our investigations and in our litigation regardless of the subject. So in the particular example I'm sharing with you, we rely on experts on the types of issues that are.
Perhaps we
involved
need to
in that
bring
litigation.
those, quote, experts on climate change in the SEC before this committee. Director Grewal, when it comes to enforcing the SEC's ESG disclosure rule, how do you envision determining whether a fund has incorporated ESG factors into its investment selection process when the SEC has not defined and likely cannot define just what those factors are?
Again, I don't want to speak to the rulemaking. I'd refer you to.
I'm not speaking to the rulemaking. I'm saying there is no definition. How do you do enforcement?
So the tools we have, you're talking about advisors. We brought a case recently against BNY Mellon for misstating their ESG practices. They said they were conducting a ESG review before making certain investments, and it turns out they weren't abiding by the processes that they have
Reclaiming
laid out in
my
their
time, sir.
disclosures.
Just, how are these funds expected to know what the letters ESG even mean without a clear definition in the proposed rule? And how will the enforcement division know what the letters E, S, and G mean without a clear definition?
Again, in the advisor space, in that particular case, we alleged a violation of the anti-fraud provisions of the Advisors Act. We alleged a breach of the advisor's fiduciary duties because they misstated to the investing public what they were doing when it came to how they were
Has
reviewing
the
investments.
SEC put out a definition of E, S, G?
Again, I think that's what the rulemaking process is.
But you
going to
can't
address.
enforce something that's not defined, sir.
You can enforce, Representative Wagner, lies. When an advisor lies about what
Lies.
it's doing,
Lies when they don't even know what the clear definition in the proposed rule is. You know, we really need some answers on this, Mr. Chairman. I hope that we could bring in some of these so-called SEC experts. You know, I'm highly disappointed in the lack of answers and transparency today. I yield back my time. Thank you.
Job well done. Now, I want to make sure that you have the proper funds, the money to continue to do the fine work that you're doing. Can you guarantee, my first question is this, Mr. Grewal, can you guarantee that the whistleblower program is now properly equipped, properly funded to process the current number of complaints with the money that you have and hold these fraudsters accountable?
Thank you, Representative Scott, for that question. Our whistleblower program is critical to our enforcement program. The information that whistleblowers provide about wrongdoing sometimes allow us to bring actions that we otherwise wouldn't be able to make. We have dedicated more resources to more timely resolve whistleblower applications. The numbers of applications are increasing, but we're investing the resources to make sure that the program remains the success that it is.
Now, let me briefly discuss the SEC's recently proposed amendments aimed at enhancing the rules governing its whistleblower program. The first proposed amendment would allow the SEC to pay whistleblower awards for actions brought by other entities. The second amendment would uphold the SEC's authority to consider increasing the dollar amount of an award but not lowering it. Why do you believe, Mr. Grewal, that adopting these changes is critical to continuing to protect our whistleblowers?
The changes you discussed, Representative, I think are important in recognizing what whistleblowers bring to our investigations, that it's not just the SEC sometimes, but also parallel DOJ investigations, parallel investigations by other regulators that result in recoveries that should be considered in the process when we are determining what a whistleblower award is.
You know, obviously, we're doing a lot of thinking here about how you divide the world between SEC and CFTC. So maybe I don't have a lot of time, but talk a little bit about partnership, cooperation, how's that going? Anything that, again, as we draft legislation, we should bear in mind?
So not just with respect to crypto, there are a whole host of other spaces in which we work well with the CFTC, and we run into them where issues may touch both of our remits, and we know how to deconflict, we know how to work in parallel. We did that with the collapse of the Archegos family office. They brought charges that touched on their remit. We brought charges that touched on our remit. The SDNY brought criminal charges. We did that with the collapse of Infinity Q and other cases. So we know how to work with them. We work well together, and the chair has alluded to some areas in which we could use additional guidance, and I would defer to the chair's office on those issues.
Thank you, Director. My time has expired.
Thank you. We now recognize the gentleman from Minnesota, Mr. Elmer.
Thank you, Mr. Chairman, and Ranking Member Huizenga for hosting this hearing today. Mr. Grewal, you've frequently acknowledged that public trust and confidence in our capital markets has eroded. In fact, on October 13th, 2021, you stated, quote, "The decline in trust undermines the investor confidence needed for the fair, efficient, and orderly operation of our capital markets. Put simply, if the public doesn't think the system is fair, they are not going to invest their hard-earned money." Close quote. I agree. But time and time again, you place the cause of blame for this erosion of trust almost squarely on the shoulders of industry participants and companies. Mr. Grewal, the SEC is in no way blameless here. Chair Gensler's political regime at the SEC, carried out by its Division of Enforcement, has been characterized by a focus on using enforcement to expand SEC jurisdiction at the expense of public resources, public investment in our country, and public trust in our markets. It seems clear to everyone, except maybe those at the Commission, that the SEC is not regulating in good faith. Although many sectors of the industry have grappled with the SEC's politicization of regulation over the last 14 months, it can be seen most clearly when it comes to the digital asset industry. Take, for example, industry sweeps. As you know, industry sweeps are not novel to the digital asset industry. They are a series of voluntary document production request letters as a regulator sends to everyone in a given industry who is similarly situated or is involved in the same type of activity. Mr. Grewal, does the SEC Division of Enforcement do industry sweeps?
We do industry sweeps from time to time when we have additional.
Thank you. The answer is yes. I reclaim my time. Are there currently any industry sweeps underway?
So I can't talk about investigations.
You can't talk about it legally, or you won't talk about it?
It's our policy not to confirm or deny investigations.
So you won't talk about it. All right. What do you do if a company, sir, cannot respond to a sweep letter because they're not in your jurisdiction?
If we issue a voluntary request for information, there's not much we can do. We can proceed with the subpoena and then a subpoena enforcement action.
So you do extra jurisdictional requests then?
Voluntary requests are just that. They're voluntary. They're an important part.
Again, sir, I'm not asking about the request now. I'm asking about the people you direct those to. There are some that would be within the SEC's jurisdiction. There are some that are not. My question is, and I think you've confirmed it, that you do industry sweeps to extra jurisdictional market participants, people you do not have enforcement authority over.
we subpoena individuals and witnesses who may be in the market participants.
Are they within your jurisdiction and outside of your jurisdiction?
We're not limited by our jurisdiction. When we're collecting evidence, we follow the evidence wherever it leads and to whomever it leads. There may be someone who doesn't work in the industry
So,
who might have
I
information.
would say, sir,
Go after them.
I would ask you, so you do extra jurisdictional work. Some would argue that that's not appropriate. But Mr. Grewal, has Chair Gensler ever directed you, or to your knowledge asked any of your colleagues, to make it a bloodbath for companies who don't respond to a sweep letter, which are voluntary?
No, that's not happened.
Interesting. We've become aware that Chair Gensler has in the past directed the Division of Enforcement to send a sweep letter to a particular sector of the crypto community designed to jam them into a violation that is allegedly unconstitutional. And if any company does not respond to said sweep letter, which I'll reiterate, as you've said several times, are supposed to be voluntary, then the SEC would make it a, quote, bloodbath for them. If true, I imagine such a tactic would significantly erode trust between the public and the SEC. Here's the problem. The SEC isn't interested in clarifying what areas of the crypto industry fall under SEC jurisdiction. We know that because FinHub, that you've referred to, the SEC division focused on crafting crypto regulation, has essentially dissolved under Gensler. Nonetheless, while abandoning good faith attempts to clarify how the Commission's existing authority applies to digital assets, the SEC is hell-bent on expanding the size of its crypto enforcement division and using enforcement to unconstitutionally expand its jurisdiction. Under Chair Gensler, the SEC has become a power-hungry regulator, politicizing enforcement, baiting companies to, quote, come in and talk to the Commission, then hitting them with enforcement actions and discouraging good faith cooperation. Understand, sir, there is a new day coming. Thank you. I yield back.
Thank you. Some 341 of our colleagues have yet to record their votes, so it looks like we can conclude. The ranking member is recognized for 1 minute for a concluding statement.
Mr. Grewal, while I'm appreciative of you being here, this is too little, too late, in my opinion. And frankly, on the too little, I would observe that neither side really got answers from you. There was a lot of need to talk to somebody else, need to talk to a different division head. It causes me to wonder how we are going to get those answers. And it's true, maybe the other side's a little more polite about it, but we need to have these answers because this is our constitutional duty, as we, according to the Constitution, are the purse bearers for the U.S. government, meaning you have to come to the House of Representatives for appropriations, and this committee works with our FSGG counterparts on the Appropriations Committee to deal with the policy and the funding of it. So we better start getting some answers when you are, especially as you're coming up and asking for more resources. I do want to correct one thing on the ALJ situation. The breach happened in 2017. The SEC disclosed the breach in April of 2022, the statement, but according to the Wall Street Journal, the breach was discovered in fall of 2020. That lack of time of being transparent and open and honest with this committee and with the public is problematic, and my time is up.
Thank you. I want to thank the witness for joining us, enlightening us with his comments. There have been a number of comments of our colleagues about the need for definition. No definition is more important than to define security, since that's what the SEC does. Congress really hasn't acted. The courts have acted with the Howey test, which was not focused on digital assets, since it was written in the 1940s. But the fact remains, XRP, I think, clearly is a security, and we need enforcement not only on those who issued the unregistered security, but those who provided in exchange for it. Likewise, it would be good to have a definition of ESG, but right now companies and mutual funds put forward their own definitions of ESG and promise the investors that they will follow them. When they don't, that's when enforcement is called for. It is not enforcement by regulation to take a security, which it clearly is a security, I believe, under the Howey test, and to enforce our rules against it. Of course, more clarity would be helpful. My Republican colleagues have said that there's no formal rule that has been adopted on ESG. We understand that. You still need to go forward, and it's my understanding that you're going forward in those areas where they're not meeting their own stated standards. This hearing is adjourned.